Yes, Mr. Thompson, good morning.
Good morning, Chief Justice Ireland, Justice Botsford, Justice Gantz, Justice Link. My name is John Thompson. I represent Leighton Burgos in this appeal of his conviction of first-degree murder and the denial of his motion for a new trial. Pardon me. With me today is my partner, Linda Thompson, who worked with me on this brief. This morning I'd like to address two or three of the series of errors that we have briefed on this case, beginning with the problem created by the testimony of Wilfredo Rosado, who I've referred to as Wilfredo here to distinguish him from the name of the case, Rosado, which, pardon me, I think controls the analysis of his testimony. Wilfredo was one of two rewarded Commonwealth witnesses who claimed to have been accomplices of Mr. Burgos's in the murder of a woman in a drive-by shooting. There were three trials in the case, and Mr. Rosado testified, or Wilfredo testified in all three. This was the third trial. Wilfredo had given four statements, three statements before he settled on this fourth one that he presented at trial, and it was essentially the factual theory of the Commonwealth's case, Wilfredo's fourth statement. These were not refinements of one statement. It was not a progression where he changed a few details. These were four different accounts of what had occurred. And the evidence showed in the first trial that his testimony was scripted. That is, his agreement with the Commonwealth, which was never reduced to writing, was that he would testify consistently with his September 29th, 1994 statement, the fourth statement. The first one had occurred on August 25th, 1994, the second one on August 26th, the third one on September 14th. In all of those, he was unrepresented. He was a juvenile. In the before the fourth statement, he was assigned counsel. His counsel had discovery, and he and his attorney met with Assistant District Attorney Picknally and made an agreement. That is, described in some detail in Wilfredo's lawyer's affidavit that's in the appendix at pages 55 to 57. Attorney Schubert's affidavit shows that he approached the Commonwealth, he approached the prosecutor at Wilfredo's request. He assured Wilfredo that the prosecutor could be trusted to keep his word if they made an agreement. The prosecutor spoke personally with Wilfredo and assured him that he would receive consideration for his cooperation. And then Wilfredo, his lawyer, the two detectives, and the prosecutor sat down and the statement was developed. There was the only testimony or the only evidence of the nature of the agreement that the Commonwealth presented was Wilfredo's testimony. His testimony was that he was going to receive consideration for cooperation. In Burgos's trial, Wilfredo said that he had not made an agreement, and his lawyer had not made an agreement with the prosecutor before he gave this September 29th statement. He was asked, this statement was made after you worked out a deal with the DA's office, right? He answered, there was no deal worked out. He was asked, wasn't there an agreement between your lawyer and Mr. Picknally? And he said, I have no idea. He was asked, do you know whether something was worked out? And he said, no. This was false testimony. It wasn't known to defense counsel at the time to be false, but from Mr. Schubert's affidavit, it's clear that this was false. And Mr. Picknelly had spoken directly with Wilfredo before he gave that statement, and that testimony was not corrected. Now, the agreement...
As you know, defendants, when they characterize agreements, are not necessarily extraordinarily precise. Characterizing an arrangement in which the prosecutor will take into consideration what the person says may not have been seen by this defendant as a, quote, deal. Are you saying that whenever that happens, the prosecutor has to stand up and say, or go to sidebar and say, Your Honor, that's wrong. I had already said that I'll take into consideration what he would say if he were to cooperate? Is that what you're basically saying the prosecutor should have done here?
Yes, that's what I'm saying, Justice Gantz.
And was there any, in the opening statement, he made reference to the fact that there was this arrangement or this promise. Was there any confusion by anybody that that was the deal and that that had been made, that was part of the inducement to have him actually tell the truth?
Yes, I think there was. As a matter of fact, there was a lot of misinformation. Let me go to the, first of all, I think it's clear that these kind of agreements are extremely important to the basic due process protections that the defendant is entitled to in a trial. That is, when a witness has been put in a compromising position, that he's being rewarded for his testimony, that creates an incentive for perjury, an incentive to either shade or lie in favor of the Commonwealth. That's acknowledged. It's a practice, therefore, that has to be carefully regulated for the defendant's protection. One of the things that this court...
Before you follow up on that, did the judge in his closing instructions tell the jury that they should view with caution his testimony because it derived from an agreement?
No. He said that the...
He didn't give the Champa instruction?
He did not. He said that the agreement, that an agreement could be taken into account, but he didn't say that they should look at the testimony with caution or skeptically. And was he asked to? He was not asked to. He was not asked to give none of the Champa safeguards were followed here. There was no written agreement. One of the things that really is essential to protecting the defendant, that is, in the Miranda case, this court said, as the Supreme Court said in the Hoffa case and the Fourth Circuit said in the Levinite case, the defendant's entitled to have any agreement between the Commonwealth and its witness disclosed to the defense, disclosed to the jury, subjected to cross-examination, argued to the jury, and accompanied by a cautionary instruction, a strong caution that the witness's testimony should be looked at with skepticism because of the risk of false testimony. Now, in addition here, we've got the two elements that this court said in the Rosado case in 1990 makes testimony inadmissible when it's given under this kind of an agreement. That is, the agreement was that he would testify to a specific version of events. That was the one that was set out in his September 29th statement, and there was nothing in his agreement that required him to testify truthfully.
But the basis for all of that is a single statement made during the Carrasquillo trial on cross, right?
That's right.
I mean, at which nobody at the time or since, till the appeal, view to be an agreement that said you will testify to what you said on September 29th, regardless of whether it's true or not.
Well, let me respond to that two ways, Justice Gantz. Number one, the rule in the Rosado case, was not that the agreement has to be that you will testify to a specific version of events, whether it's true or not, and no matter what. Okay, there were two elements, two things the court said about that. First of all, it was an agreement to give conforming testimony, to give specific scripted testimony. That obviously creates the risk of false testimony. The second thing was that the agreement, and this was in Rosado, it was a written agreement, the agreement expressed no interest in whether he told the truth. Okay? That is, not that it said that he would lie if he had to, but that it said nothing about whether he had to tell the truth. That is the situation here. And I think it's important to look at the facts of what came out in the Carrasquillo case, because this is not an interpretation or a glancing comment. This is a cross-examination that goes like this. Defense counsel, they only offered to help you once you said you were involved and that Mr. Carrasquillo was involved. Isn't that right? No. Well, that's when they offered to help you. That's your consideration, isn't it? Well, yes. Yes. So it was agreeing to come into court and give the same statement to this court that you gave on September 29th, 1994. Uh-huh. That's what you're going to be helped for, right? Yes. And nothing else. Nothing else. And that's the thing for which you're going to get consideration, and nothing else? Nothing else. If only you testify to what you said in your statement of September 29th, 1994, yes. So 4 different times the witness confirms.
Doesn't the judge deal with that in his opinion in the motion for new trial?
The judge, Judge Ford said he didn't mean that he was that this was his consideration. He meant something else. We argue, and I think that it's clear, excuse me, that that's an abuse of discretion.
Well, I mean, what the judge essentially said was, the witness essentially says, I lied at time 1, I lied at time 2, I lied at time 3. I told the truth on September 29th, and I'm agreeing to do it. And the judge said, implicit in that, or what he really was saying, is that I agree to tell the truth. That was what he meant and what was understood by that, not that I'm limited to what I had said, but that I've come clean and I'm going to testify to what I said when I came clean.
Well, that's 2 different things, Justice Gantz. One is the question is he claiming to tell the truth? That is, was he vouching for his own truthfulness? Clearly he did in his testimony. Did he talk about his agreement? Yes, he did. Did he say his agreement was to tell the truth? He never said that. The prosecutor never said that in his disclosure to the defense that's in the appendix. He never said that in his representation to the judge of what the agreement was. He didn't say that in his representation to the jury of what the agreement was.
Are you talking about this
case or Carrasquillo? The witness never said that. I'm sorry.
Are you talking about this case or Carrasquillo?
I'm talking about Burgos. During the Burgos trial.
It's the same statement, though, right?
It was the same statement. It was the same witness. This testimony from the Carrasquillo trial was not used in any way in the Burgos trial.
But didn't Judge Ford say that in Carrasquillo and I'm not going to, is it Moray? Is that how you say the name?
Moray, yes.
Okay, Moray. In both of those trials, that in substance, the witness, there was questions from the prosecutor, and the witness was agreeing that he needed to tell the truth as part of that agreement?
Judge Ford said that in his findings, but the record doesn't support those findings.
The record of those 2 cases?
The record of those 2 cases. There's no indication in the Moray case that this Carrasquillo exchange was used at all. So the fact that this issue didn't come up in the Moray case doesn't tell us anything about how that would have been interpreted. It didn't come up in the Burgos case either. It came up in the Carrasquillo case, in which there was an acquittal, because this witness, Wilfredo, and his statement dovetailed with the confession in Carrasquillo. There was a confession in Carrasquillo that dovetailed with Rosado's testimony, with Wilfredo's testimony. In the Carrasquillo case, Mr. Pignali, who the same prosecutor, said to Carrasquillo in his cross-examination, Wilfredo's not guilty. If you're not guilty, isn't that true? And he said yes. So the jury rejected both the confession and Wilfredo's testimony in the Carrasquillo case, and that's because, I would suggest, of this cross-examination. That is, this is a use of the Rosado rule. In Rosado, this court said, when there's this kind of an agreement to testify, to give scripted testimony, and the agreement does not require truthful testimony, that's inadmissible testimony on objection. But If the agreement is then disavowed, the witness can go ahead and testify. So there's little point in objecting. It simply sanitizes the witness testimony. The other way to attack this, according to Rosado and according to this court in Miranda and the Supreme Court in Hoffa, is disclosure, cross-examination, exposure of the nature of the agreement and the nature of and the risks that this testimony brings with it. That didn't happen in this case.
Okay, so maybe help me a little bit here. It sounds as if what you're saying is that the appropriate thing for an attorney to do, faced with a Rosado error, is to stay silent and raise it on appeal. Because if he were to raise it, as I guess was mentioned in Rosado, the prosecutor would say, "Oh no, that's not what we meant," and we're going to tell Mr. Rosado, we're going to tell Wilfredo that that's not part of the agreement. We're going to correct it. So if you raise it, the prosecution corrects it. If you don't raise it, you can argue it on appeal, and you're better off to do that. Is that the basic theme?
Well, I'm not advocating. That would be. I think that's a distortion of the argument that I'm suggesting, Justice Gantz. It could be you're suggesting a sandbag. Mr. Trial counsel's affidavit, Judge Gordon's affidavit says...
I'm not suggesting that defense counsel
he didn't
sandbagged
know
or
about
thought
this.
of it. No, I'm not suggesting
He didn't know
that.
about this. And nobody knew about this, or at
He
least...
didn't know about it because he didn't have the Carrasquillo transcript, or because he didn't?
He had the Carrasquillo transcript.
He just missed it.
He said he'd studied it. He wasn't aware of the Rosado ruling, and he missed the significance of this testimony. He didn't make any use of it. I don't think that this rule invites sandbagging. I think what this rule is flawed. That is, the only sensible thing to say when a witness has been corrupted like this, that is, when a witness has been given a reward to give scripted testimony, that testimony should be inadmissible. That's a problem with the Rosado rule. It doesn't make the testimony inadmissible. Then there would be a meaningful encounter, and those issues of fact, that is this really the agreement, could be resolved before trial. Okay? But the way the Rosado rule is set up, that penalizes the defendant. It didn't happen in this case either way. That is, defense counsel didn't recognize the significance of this testimony, so he didn't object, he didn't cross-examine, he didn't ask for a cautionary instruction, and he didn't argue it in his summation. So the jury was left unaware. The jury heard scripted testimony and was not aware of it. And that is in addition, that is a witness who, in addition, lied about whether he even had an agreement. And that's one of the things that this testimony would have shown. He knew he had an agreement. It was right there in black and white. So that, I think, that problem by itself requires a new trial. There was an additional problem with Mr. Vega, the other cooperating witness, whose testimony was, who had just before he gave his statement to the police in this case, had been sentenced in Hampshire County to 9.5 to 14 years in prison, and who immediately received a reward for giving his first statement in this case. That is, he was on his way to state's prison. The police or the prosecutor, the prosecution team stopped that and had him held in jail instead, and he ended up serving the next 4 years in jail, in the county jail in Hampshire and Worcester, while these other trials were going on. But when he testified, the prosecutor brought out the fact that he had these Hampshire County statements and said, "And you've been on your own. You're on your own on those statements, on those sentences. We're not helping you at all." And he said, yes, that wasn't true. He was being helped. His Hampshire sentences were being ameliorated, and he ended up, when he pleaded guilty and was sentenced, the sentence was made retroactive, that it was a nunc-pro-tunc sentence back to the beginning of his Hampshire sentences, so that his homicide sentence here in this case only added 2 years to his Hampshire sentences. He had filed an affidavit before he made his agreement with the Commonwealth. He'd filed an affidavit saying that his statement to the police was involuntary, and that his waiver of Miranda was involuntary, and that motion to suppress was never litigated. That material was available in the Superior Court file. Defense counsel did not find that and made no use of it. He didn't challenge the admissibility of this statement, of this testimony based on an involuntary statement, and he didn't use it to cross-examine the witness. And that was...
The judge, of course, said if he had raised it, it would have been denied because the intercession of 2 years and having counsel would have obviated whatever problem may have arisen from the earlier involuntary statement if it was involuntary.
That's an attenuation argument, which, of course, it was something that was not litigated. That is, and as I've laid out in my brief, is an erroneous application of the rule. First of all, the burden of proof would be on the Commonwealth in that instance. The judge relied on suppositions that aren't in the record. For example, that the attorney appointed to the witness would have done certain things that would have relieved the witness of the pressures that the Commonwealth was putting on him. But essentially the situation was, the police violated this man's right. They refused, they interrogated him in the Hall of Justice. They refused his request for counsel by telling him that there was nobody there who they could bring in to represent him. And they questioned him for 7 hours to produce this statement. Then they induced him to give the statement at trial by telling him they would reward him and give him leniency on his sentence. That, I think, is a violation of due process also. I'll rest on my brief on the other allegations.
Thank you.
Thank you.
Good morning, Your Honors. May it please the Court. My name is Diane Dillon. I'm an Assistant District Attorney representing Hampden County. The Commonwealth disputes there was ever any kind of so-called Rosado agreement. The agreement with this witness was that he would receive consideration for his cooperation. The jury was informed of that. He testified to that. He defined what he thought consideration was. People will think about it, and it depends. And I hope I get a break.
Was the statement given after there was a sort of session with the prosecutor and Wilfredo's counsel? And
on the first day he was arrested, he spoke with the police and lied.
I know this is the fourth. I'm talking about the fourth statement.
This is the fourth. You have this affidavit of Mr. Schubert. He finally got counsel. His juvenile lawyer was not available. He finally got counsel in regards to the murder case. He came in with counsel, and there was a discussion. He was present, apparently, and as I recall,
Mr. Schubert was present? Is that what you mean?
Mr. Schubert was present, his client was present, and the ADA was in and out during the course of that conversation as to whether or not he wanted to cooperate with the police.
Was there, is there anything in the record? I haven't read, I'm sorry to say,
No, that's
Mr.
okay.
Schubert's affidavit.
You have to read 3 trials for this.
Is there anything to indicate that the substance of what he was going to say was gone over, or was the negotiation, do you want to make another statement?
It was, do you want to make it? And in fact, Attorney Schubert said that their deals are always vague. That's all you can do in Hampden County. They'll never tell you what they're going to do, but you can trust them.
But, okay, no, that's not what I meant. Was the conversation about tell us what happened, and then do you want to make another statement, or was it all about do you want to make another statement?
As I understood it, it was do you want to make a statement? Do you want to tell the truth? And contrary to assertions that you've heard, he testified that he did tell the truth, that he had lied in the others, but this he was telling the truth. He told the truth from the beginning to the end, and that's what he was saying to the jury. It was the same with Vega. He said he was telling them the truth. He was really upset that he was implicated in this murder at all because he'd known the victim. He'd gone out with her a few times. He had his own set of problems from Hampshire County. He'd already been sentenced, and he wanted to tell the truth and get on with things. He was worried about his family. He was worried about going away. Well, if you tell the truth, we can help you. And that is the same inchoate agreement with him. The jury were aware, counsel were aware, and although counsel for Mr. Burgos said he was not really aware of the Rosado decision, he also never said that he thought that anybody had agreed to testify to a specific version. The only thing that there's any evidence of is all of the witnesses said they would testify and tell the truth, and they hoped that they would get consideration. And the sentences imposed were lesser, but they were more in line with the actual acts. For instance, Mr. Morey, who ordered it, he didn't cooperate, he didn't get a deal. Carrasquillo was acquitted, but he pleaded guilty to perjury in his motions to suppress. And he didn't get a deal on the perjury convictions. The guy who stole the car, young kid, I mean, that's what we're talking about with these gangs. Young kids. He stole a car and he left it. He wasn't there at a shooting. He got a lesser sentence more in line with stealing a car, although he knew it was going to be used in a shooting. And this defendant, who was the enforcer, who enlisted them, told them what they were going to do, made sure that they were armed, and got them on their way to accomplish their mission of executing the godmother of a rival gang, he got a stiffer sentence because his involvement was far more serious and he was more culpable. But everybody got a sentence. Nobody has ever, except Mr. Thompson, in this brief filed in 2008, suggested that there was an agreement to testify to a specific statement, that there was some sort of government conspiracy to get all of these witnesses to somehow get together and all say the same thing. Although there were slight variations in their testimony, they all say that Morey ordered it, he was with this defendant, the enforcer, then they got Vega and he stole the car, they got everybody together, they got Carrasquillo, they went over to the guy who's in charge of giving out the munitions, Mr. De Jesus. They didn't have their own warlord, they had to go to High Street. They went over there that day after the mission had been set. They got the guns. This defendant had masks, he had gloves, he got in the car with them. Do you know where you're going to go? Yes, he knew where they were going to go. They were going to go and shoot, and they went where they were told, and they killed the woman they were told to kill.
Now, you refer to this as a, quote, inchoate agreement. Are you denying that there was a cooperation agreement?
No, 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 no. Absolutely, there was an...
These weren't specific, is that what you mean?
It's not specific. It's hard to know what degree of cooperation you're going to get, so it's hard to know, especially before trial, because especially in murder cases with gangs, you're investigating right up until the time you go into court, and you don't know who's going to come in and say what. But the degree of cooperation is dependent on the degree of consideration or the amount that's given.
And was that, I mean, I guess part of the problem I have is that, well, the federal government always incorporates agreements in writing.
I understand.
DAs rarely do.
Right. We're better about it now.
Good. Is there any consequence to the apparent ambiguity or the risk of confusion with this type of agreement in terms of what it is versus what's understood by the defendant and how it's articulated to the jury?
It was never raised until this appeal. None of the people participating in this trial thought that there was anything that was untoward that was done. Their clients cooperated, they got consideration. The jury was told by the prosecutor ahead of time, there are consideration agreements. If they cooperate, they'll get consideration. And part of it is, I've forgotten which ones, the mother got $500. He told the jury ahead of time what it was. He elicited it. The substance, and this is from Shan, the substance of the agreements were put before the jury. The witnesses were cross-examined. The judge told the jury in his instructions to scrutinize cooperating witnesses. That was done.
Scrutinize them. That was said.
That
what was the
was.
language used? Do you recall?
I cannot quote it for
okay.
you. I'm sorry, Your
But I mean,
Honor,
but
but
he-
I did
but
cite
he-
the page in my brief.
But it wasn't peculiar to Wilfredo Rosado.
No, because he wasn't the only cooperating witness, Your Honor.
And it wasn't Champa language in full.
It was generally Champa language. It's the gist of Champa if it's not a quote of Champa. But instructions are reviewed to see whether or not the jury got the gist, the information, that they should scrutinize cooperating witnesses. This is something they knew from the beginning of the trial to the end of the trial. Do you have any more questions on that, or would you like me to touch on some of the other issues?
I'm just, there may be...
I'll be happy to stay on this.
Just one question. The nature of this agreement, obviously, it seems to me, has the risk that, depending on the level of cooperation, could be understood as depending on how close you get to what we, the Commonwealth, want your story to be. I mean,
There's no evidence of that, Your Honor. And in Arriaga, they said it's not like this was an outcome determinative agreement. There is no evidence of that except for that single 6 lines or whatever it is in the middle of 87 pages of cross-examination in Carrasquillo. That's the only evidence, and nobody else picked it up. Nobody in any trial, and they all had the transcript. None of the attorneys, only one other case has gone to appeal, but it wasn't picked up on appeal. The judge didn't see it, and if he said that if he thought that there was something corrupt about this agreement, he would have called them up.
If I could turn you to the closing argument for a moment.
Yes, Your Honor.
Argued that the jury should infer that Los Salidos was responsible for the shooting because La Familia thought that they were responsible and shot Ricardo Negron in retaliation.
There's evidence that Los...
Fair argument?
Yes, Your Honor, based on the evidence.
So the jury should say that because a gang thought that another gang was responsible and retaliated, that they should infer that, in fact, that gang was responsible?
I think that the evidence that Morey, the president of Los Salidos, called the apartment shortly after the murder, about 2 hours later, and spoke with this defendant and said, there's going to be trouble. Tell nobody to leave the apartment. You've got to stay there. So this defendant told everybody not to leave, but some of them did leave. And as Ricardo Negron was crossing the street, someone came up and said, you're a solid, aren't you? He said nothing, and he was shot 5 or 6 times. He went back into the apartment. The defendant came down and said, I told you not to leave. I think from that you can infer that Morey, the president, knew that they had done that, knew there was going to be trouble, and there was, in fact, retaliation within hours of the shooting.
Okay, but that's... the prosecutor, I gather, in his closing did not basically say you can infer from what Negron and the defendant said that supports the view that they were responsible for the shooting. He basically said, because La Familia retaliated, that means that you should infer that La Familia knew what happened, and therefore you should take their understanding as part of the evidence.
I think that the evidence of retaliation was developed through trial by what I've just suggested to you, Your Honor, coming from the prosecution, and also the affidavit from, appended in the record, the investigator for the defendant had gone out and spoken to these people, and they had information from Negron that he was shot before Sylvia had been shot.
That goes to calling Negron in the first place.
And they called Negron because they did not anticipate Negron would say, I don't know when I was shot. That was just not something that defense counsel should be charged with knowing, especially after Negron had said something other to him when he was interviewed.
No,
but this was a theory of retaliation.
Well, let's go to Negron for a moment. Turned out badly, I guess.
20/20 hindsight, perhaps.
But was it 20/20 hindsight to not recognize that Negron would have indeed testified to a conversation he had with the defendant at or about the time of the shooting?
What they anticipated that Negron would say was that before the 27th and the 28th, which was all of the Commonwealth's evidences, they met on the 27th, they did it on the 28th, pursuant to an order issued on the 27th and the plan that they evolved on the 27th with these people, including this defendant, the enforcer. So they anticipated that Negron would come in and say, no, it was earlier, it was not, and he said not on the 27th, that these other people said that they were charged with killing the godmother of La Familia. So if he were to come in and say that, it would undercut the Commonwealth's theory of the case. It would undermine the witnesses that the Commonwealth had called to prove that Morey issued the order on the 27th and told Burgos and Vega that they were going to carry out these orders. And it would not be unreasonable to call a witness who would, in essence, impeach the Commonwealth's main witnesses.
Okay, but maybe I'm wrong, but didn't Negron testify that that conversation 2 weeks earlier involved the defendant?
Yes, he did. But it was that Harry and JoJo were telling the defendant that they were told they had to kill someone. And it was really the first time
and
that...
was that inconsistent with the defendant's role, since we're speaking about a hierarchical gang, and he takes orders just as everybody else does?
It wasn't that he was told, the defendant was told that he had to do it earlier from Negron. It was a conversation, Harry and JoJo saying some person told them they had to kill him. So it could have been one of their conversations while they're just sitting around the apartment, not the president coming in, saluting everybody, going in the bathroom, and then issuing orders about how a mission is going to be carried out. So when he made the decision to call him, it was not manifestly unreasonable. As it turned out, it may not have been all that he had hoped for. But the decision to call the witness was not unreasonable based on what he knew at the time he called him. And that is the standard of review on that matter. I would be happy to answer any questions you have. The idea that the standard of review has been skewed in this case is something that I quite simply do not understand. 33E, you go through everything to determine whether or not there was an error in the trial. And this has always been said to be, and continues to be said to be, a higher degree of scrutiny than the constitutional standard enunciated in Safarian. So the allegation that counsel's performance has somehow deprived this defendant of a standard of review cannot be correct. And I would suggest that when you do go through this on 33E review, you might consult with what Justice Graney said at the end of the Morey decision, when he said that the evidence against Morey was substantial, that he had ordered this, and the facts say how it was carried through. They mentioned the defendant in this case. He called it a senseless act of violence committed in the name of the gangs in Los Salitos. And that is what we have here. There was a woman sitting on her front stoop with all of her friends, and as soon as the kids went away, these guys drove by and shot her.
Actually, what does it mean to be the godmother of a gang?
It's like a very grim fairy tale. We've got the godmothers there. We've got enforcers and warlords over
Is the
here.
godmother analogous to the godfather, just a woman? I mean, the person in charge? Was that the
Fortunately,
testimony? Or was
my
that,
experience with gangs has all been through the
but
courts.
during the course of trial, was it ever articulated what her role was beyond her being the godmother?
No.
She was a young woman, right?
Yes. They're all young. That's the sadness of it all.
All right, thank you very much.